Hey, right, everyone, we'll just wait for Will and Shannon. Oh,
Hello.
well, how's it going?
Not too bad, thanks. Not too bad. Good to be back.
Yeah, no, it's nice to have you. Yeah, you right, Shannon? Cool.
Evening.
Okay. Hi, everyone. Usual stuff. Let me just get it out of the way. So, please don't put personal data in the questions. Just ask the questions as if they're about someone else. We've only got, well, we've got one questions coming through the week, but I've actually got two more that I might throw in. Plus, we're going to talk about some other stuff as well. The live stream chat will be visible uh, for the duration of the live stream, but then it just disappears magically. I don't even know how to stop it doing it. So yeah, so your kind of personal data or whatever, or your data in general will kind of vanish at that point. But as I say, don't kind of disclose stuff about yourself. Just make it as if it's a hypothetical question. So I think that's it. Little bit of a notice. So 2 weeks time, but this time, so two Thursdays, 23rd of November, 7:30 till 9. We're running a free online event called the Homelessness: The Ethics of Gatekeeping, and it will basically be 90 minutes crammed with people, three of whom are lawyers, talking about gatekeeping and basically how it happens and how it could ever stop. So, among other things as well. So, yeah, check out any of our socials basically for more information about that. So, Eventbrite and whatnot's got stuff on there. Facebook's covered in it. So yeah, and we're sort of announcing our panelists. So panelists so far, Professor Luke Clements, who's like he writes the textbook on social care or adult social care law, but he also wrote an amazing book called Clustered Injustice, which I think we mentioned before. Giles Peaker, who's the Nearly Legal blog guy, and Sarah Steinhardt, who you may well have seen on our channel before, who's a barrister and deputy district judge and just generally awesome. Plus a friend of ours, Marnie Burden, as well, who's kind of worked as a housing officer before. So yeah, should be amazing. Basically, you don't actually need to sign up to it on Eventbrite because it will just literally be in this normal slot. So hopefully you'll see you there. Okay, cool. We've got some questions coming in there. Oh, wow, Struth. Last week there was none. Now there's four or something already. On the agenda tonight, so we can't not talk about Suella Braverman's comments about people in tents having a lifestyle choice to live in a tent, and then the response from the homeless sector. But I don't know. Shall we try and let's just try and see if we can get through some of these questions first of all, so we don't leave people hanging. So hey, you right, everyone? Hi to the regulars. Have we got any regulars here yet? So first question that I can see is a birth certificate mandatory for housing officer to make a decision? Good question. It's surprising how this comes up in making an application as well. So I've had housing officers before tell me that unless the individual has a birth certificate from day one, they won't accept the homeless application in the first place, even where there's no reason to doubt their identity or anything like that. But there will certainly be certainly standard documents that will be requested by the council during the course of their inquiries. The birth certificate or ID will be one of them, um, as well as things like 3 months bank statements, things like that. Now, in one sense, I guess there's nothing that says in the law that you have to provide a birth certificate, but the council does need to be satisfied that it owes you whatever duty it owes you. And I think it's probably well within its rights to request want to see a birth certificate or other photo ID or photo ID or whatever. Um, but it might also be things like your kids and stuff like that. They might want birth certificates of your kids and things like that as well. So they certainly need to be able to identify who you are, and they might be able to do that without a birth certificate potentially. But they certainly, that's not unreasonable for them to ask for ID. You can get a birth certificate. So when we worked at Just Us, we had like a budget which was you pay £38 and you get a birth certificate replacement within a couple of days. And it's amazing how little information you need to actually get that birth certificate. I don't really see why it's actually used as a form of ID because all you need to know about someone, I think, is like where they were born and and their name. And I think, and kind of you can kind of guess at the hospital and stuff like that. It really doesn't need much information at all to kind of get it. So yeah, but that's as I say, it might well be that there might be a local support charity or something that would have a budget for that sort of thing if you're not haven't got the finances to pay that. And I think it's something like 13 quid or something if you want the longer term, the kind of the slow delivery of it. But yeah, so the thing that's
If
that's all I want to say about that. But feel yeah, go on.
guess I'm just going to throw out a question. I guess if it's a duty for the council to make those inquiries and a duty to, make sure they are who they say they are, is the cost then not on the local authority?
I don't know. Will?
Yeah, I think it is. And I think that just jump onto your answer as well. I think that the local authority are entitled to ask for a birth certificate, but they're not entitled to make it a sort of prerequisite of processing your application. If for some reason you didn't have one, they could always get your authorization and obtain it, and they would have to pay for it. I've been having this lately with Hammersmith, London Borough of Hammersmith and Fulham have been asking for about can you get medical evidence, and they want. I did get a report from a psychiatrist about somebody, and they said, "Could you get another one?" And I said, "Well, no, I can't, because the legal aid agency won't pay for it at the moment. But you're welcome to do so if you want to pay for it. But I'd have to wait until there was a legal dispute. But I can't. The danger is they are asking people to provide a lot of stuff, and I think they shouldn't be asking for all of this proof stuff at the beginning. But I'd draw the line at asking people to pay for it. That's unreasonable.
Yeah, I'm just thinking. I think it's at Owies v Birmingham where the judge says it's basically for the council to kind of be satisfied, and it's not for the applicant to prove their case. I can't remember if that comes up in the code of guidance as well, but it's certainly in case law. So yeah, there's other documents they may well request, which should actually come with a charge. But yeah, I've never put the cost back to the council when insisting on a birth certificate, but that's because we've had an easy other option to do it. So yeah, I don't know, but I think certainly in terms of requiring one, because I guess this is too much information. So it's down to the council what inquiries they make. So they don't have to ask for a birth certificate. They don't have to ask for ID really. They just need to kind of, on the balance of probabilities, be satisfied that you are who you say you are, and they have a responsibility to make sure that they're not, kind of subject to sort of fraudulent claims or whatever, and end up giving housing to people who aren't eligible. It's reasonable for them to kind of want to do some checks. But there'll certainly be other ways of doing it. So if you had a driving license, for example, that's much better actually than a birth certificate. They shouldn't insist you have a birth certificate as well, unless, I don't know, the nationality might come into it or something. I'm not sure. But yeah. So anyway, hopefully that's answered that question. Man, I need to move my other computer a bit closer because I can't read it. So we've got someone, friend, is a single mother and homeless. How can someone win a lawful judgment or decision from court against a team of housing officers, including her landlord, who are abusing? Let me see if there's a follow-on bit from that. Oh yeah, and it goes on to say, how can housing officers get a penalty for abuse of power, and how may I know? Guys, can you just make sense of this? Because my screen is flashing up. I can only see half the text. So I've got this like icon keeps flashing up in front of half my chat, which is annoying.
I couldn't.
I think it's saying like how can you know who they say they are when they're calling? Because often, I guess housing options might like ring from a withhold number, and if they're asking lots of personal questions, then there is a point there where how do I know who you are? Like, you're not giving me your name potentially, or you're not proving that you're who you say you are. I think that's the second half of that question.
Yeah, okay. So let's try and tackle that in order. Yeah, you're right, Andrew. Nice to have you here. Um, so so I guess I guess it just depends. I mean, this sounds like there's something's gone badly wrong here. I don't know if this is helpful to say. When I worked in a council, certainly council teams did explicitly gang up on applicants and basically conspire, I would say, to kind of do something to them, whether it be deny them a lawful judgment over. I certainly remember them conspiring to put them in the worst possible property they could find for them. So it's not complete, paranoia to kind of have that kind of experience. But I'd say the chances of winning anything is incredibly low, ever. with that sort of thing. I think you may well be able to win a decision in terms of whether it's a priority need decision or a intentional homeless decision. There's a pretty straightforward process for challenging that down the review process. But certainly where, as I say, I saw team members falsify records and forge signatures and stuff like that. So it does happen. You're just never going to be able to catch them unless you catch them red-handed somehow. So I know it does happen, but I'd say you're probably not going to get too far with kind of going down that course of action. In terms of abuse from a landlord, it's probably a little bit more straightforward if it is kind of clear-cut abuse. So you can maybe talk to the adult safeguarding team or something, or even the police if they're harassing you. But I don't know that you're really gonna, you're gonna win anything meaningful, and I don't even know what the penalty would be if they were caught doing it. They might get internal disciplinary or something. It's not gonna change your life, I guess. So I'd say, as difficult as this may sound, I think there's times when you just give up on certain things, and you just play, you just kind of try and move things forward. So yeah, I don't know if that makes a great deal of sense, but certainly challenging a standard decision. In any decision they make, they basically need to explain in writing how you challenge that decision, and usually it's basically asking for a review of the decision within 21 days of receiving the letter. The only exception to that is actually, I guess, one exception is if they're saying that there's no reason to think that you might be vulnerable when you make a homeless application. So they're basically saying that Section 188 is not engaged. They don't have to give that in writing, as far as I know, and there is no right of kind of review to that at that stage. You just have to go get a solicitor and go to court to kind of fight that sort of thing. So it's difficult for lay people. That's the problem we've always had when we're having a council that's so perverse that they're denying that somebody even might be vulnerable when they're clearly very vulnerable. So we would have to take that through the complaints process. I did have a lot of success with that by just going to the head of service and complaining to the head of service and just explaining what the law was and how they were misinterpreting it. Just something I always keep an eye out for is when people talk about Section 188, I keep hearing people getting mixed up. So they say reason to believe that you are in priority need. That's not actually the legal test. The legal test is reason to believe that you might be in priority need, which is an even lower threshold. Now, it might seem really pernickety, but that's actually a different test and it's a lower threshold. So just kind of keep an eye out for that one, where you sort of hear housing officers talk about reason to believe. That's not really the most important bit of that test. It's that they might be, there's reason to believe it's possible that they might have a priority need or be homeless or whatever. So yeah, anyone else want to add anything to that? As I say, I feel for the person in the situation because there is definitely corruption within some teams for sure. I just don't think there's anything useful you can do about it. I think you just have to kind of lump it, unfortunately.
Yeah.
I mean, I think you're probably right. I think particularly when you've got those housing officers that are sort of, hell bent on making it difficult, even sort of, I mean, it might be worth doing a subject access request and just seeing, because it's amazing sort of what people forget to cover their tracks or what they might be writing in emails about you. And again, just, I guess, like going forward, if you have those phone calls, if you've got a smartphone, I think you can download sort of screen record apps and then you can record the conversation. So even if, they are, say, abusing or what have you, you've then got a copy and you've got evidence, or get another phone that can then sort of record your conversation on loudspeaker. And it seems like we're being really paranoid about this, but actually this happens. It's worth doing it. And I think, Mike, correct me, but you don't have to tell them that you're recording it because you can't actually use it necessarily like further down the line. But there might be power in saying, look, I am recording this just so you're aware, because this is a legal process. And you can sort of do it that way instead and say, look, because it's a legal process, I'm recording this just so I can remember what's being said for, what I need to do. But I think otherwise, yeah, complaining and going down that route is probably your best bet. Maybe requesting a change of officer, whether that's same gender or what, like you've got options there. And again, if it's that sort of bad, maybe raising a safeguarding alert but otherwise I think Mike's probably right on that one.
So yeah, Shannon's really two really good points there. So there are cases where covert recordings have been admissible in court as and they've been used. But what you can't do is you can't make a covert recording of someone and then go and show it to your mates. You have to basically keep it. And then if down the line, you know, the housing officer's lying about something, you can then raise it. So I've done it with an LGO investigation once, where we covertly recorded the officer, who basically, you know, she told the LGO that that the guy had never told her about any medical issues, and actually the recording showed that he spelt out the medication to her to make sure that it was passed on. So it can be done. There's a case called Vaughan v. Lewisham, 2013. It's an employment law case if you're ever interested in looking at. There's other cases as well, and you can't record stuff when you're not in the room. That's another kind of little thing with that. But it sounds, as I say, it sounds really paranoid. Luckily, a lot of housing officers are decent and don't do this stuff, but you do get those odd ones who are just bad. And the subject access request route that Shannon's mentioned as well. So we've certainly had cases where there are emails that they really don't want us to see has been discoverable. You know, it might be like we had a team leader instruct her officer to kind of basically put a letter on the system from a year ago, or like make a letter, backdate a letter from a year ago, which was a bit shady. So yeah, there's subject access requests are kind of a really important tool in all this stuff. Had another thought as well, but it's now gone. So might come back to me. But anything else on that one, guys? Hopefully.
Could I just check with you, Mike? When you said you can't show it to your mates or play it to your mates, what did you mean by that? Because
so basically, it's confidential. So you could show it to you could, if you had like a professional supporting you, I guess you could maybe show it to them, but I guess it'd just be like a breach of confidence if you could, showed it down the pub. Oh, this is my housing officer. I've covertly recorded them. That's not, as far as I know, that's kind of outside the realms of what you can do with it. So really, you're recording it as a kind of a means of, potentially eradicating fraud or kind of misconduct. You can't.
It's a very common question that I get asked is, can I record this? And I tend to find as well that if somebody says to a housing officer, I'm recording this, it's taken as quite a confrontational statement, and it's quite common for housing officers to respond by saying, well, you're not allowed to do that, and I'm ending. And one form of gatekeeping I find quite a lot is trying to provoke somebody into behaving in a way that you might say, I'm not going to tolerate this kind of behavior. We have zero tolerance for that, and I'm ending this conversation. So I've had people be told, no, I'm not going on with this if you're recording it. So it might be best not to tell them.
Yeah. I mean, social work has the same issue where they get very. There's even sometimes like internal like council policies and stuff, but policies don't overrule the law. So there was a case. That's what I was thinking of. In the last 6 months there was a case where one housing officer was basically slagging off a client and accidentally sent the email to the client rather than the staff member it was aimed at. It was an LGO case, I think. So occasionally you can kind of, they kind of can be kind of held to account for it. Not that anything happened in that case really, but yeah. So yeah, hopefully that's kind of been reasonably helpful.
Great, yeah.
Just look at the next question there. So again, I think this question might have popped up before. So someone returning from Ireland to the UK in order to get medical NHS medical treatment, and will be applying as homeless to housing department. So so I guess the question here, like, is that possible? I don't know if there's a statement there, but rather than a question, I think we got a little bit stuck with this one before. I think taking this one to the Facebook group might be a better way to get a response, because I think my understanding of the common travel area is you can come back from Ireland and immediately you're eligible for all benefits basically, but I don't know.
I think there's a follow-up comment there about it's being concerned about intentional homelessness due to leaving the accommodation, and would returning to the UK for medical treatment be a valid reason to leave accommodation. And I guess depending on the treatment type, and obviously there's a cost, there is a cost for medication and treatment in Ireland. So actually, if you can't afford the medical treatment, it would be unreasonable for you to continue to occupy. So then is that a push? And then you would be intentionally homeless?
I think that's right.
Or, yeah?
I'm just thinking how there's that kind of like the sixth kind of parts like logical kind of definition of intentional homelessness that you'll often see within the within the kind of the section 184 notification. And I guess you get them, is it reasonable to continue to occupy accommodation? I think that's probably one of the 6 points that you want to, because it was the accommodation available. Did was it the result of your deliberate action that you kind of ceased to occupy it? So but I think the reason I don't know of any case law on it. Again, that might be an interesting one. I might have a little dive around in some case law on that just to see what there might be about it. But I think, if it's, I guess it comes down to what healthcare is available in Ireland. Again, I don't know. If it's going to be slightly better in the UK and that's the reason, then they might say, well, you can get the treatment in Ireland. So, it's kind of not going to fly. I don't know. Yeah, it's a waiting list issue. Okay. Oh, right. So the health treatment. Okay. Yeah. With you. Okay. Okay. I guess so. The other question I've got there is, so you're coming back for medical treatment, but I don't understand why you give up the accommodation. So you might, come over for a short stay, but I think presumably, unless you're going to give notice on a property in Ireland to come back to get, says here cataract. Is that say cataract again? I can't see cataract surgery. So it's kind of like, well, that's cataract surgery is like just a very short, usually just a kind of a half day operation per eye.
But I think, wouldn't you have to, if you were in England, living in England, and you weren't a citizen, you'd then have to pay for the surgery. So it's a waiting issue in Ireland, and it's a price issue in England if they don't give up their accommodation, I think.
Yeah, okay. So basically, whilst you have accommodation available for you in Ireland, you can't get the free treatment in England. Is that right? I don't know.
I think so.
Yeah, okay. I just don't know. I don't know how I don't know enough about the health system and what your kind of your rights are and your recourse to public funds are, because I presume that's is that kind of a secondary tier health service rather than a primary one? So because primary care, I think anyone can get it, but I don't know. It's good. It's an interesting question. I just don't know the answer. I think I think it's a risk. It's probably the best I can do. I think you risk being found intentionally homeless. But I don't know. As I say, I think put that question into the Facebook group and see what you get back, because it might. I think it's one of those ones where you have to kind of like look around in some textbooks to see before you kind of give a full answer. So yeah. Okay, so I think we've just also got one. Okay, just going back to the birth certificate issue. Housing officer threatened me if I don't show him a birth certificate, he'll cancel my TA, even though I sent him my British passport. He wants birth certificate. Is it an empty threat? Isn't it illegal? So it's not an empty threat because they might end your TA, but whether they can do that lawfully is a different question. There was a case recently where it was a Westminster case, and basically the applicant just refused to cooperate, refused to provide evidence that was reasonable for the council to request. I think it was like medical evidence about his conditions. So he kind of made some assertions about, he had X health condition, and there was some evidence of it on the GP stuff, but it didn't kind of say exactly what he was saying. And he just basically refused to cooperate, and it didn't go well for him. Basically, it didn't go well for the case. The inference is that if he just cooperated with the request, then he would have been in priority need or whatever the issue at stake was. But he didn't. So I think housing officers might be being difficult. I guess the question for them is, why do they need to see the birth certificate? If you've shown them the passport, what are they concerned about? If are they concerned about your identity, or is it just them being a bit difficult? But I think and I guess the question is why. Yeah, how easy would it be to get a replacement birth certificate? Because that might just be the simplest thing to do here, is just to get a replacement and just deal with it that way. And as Will and Shannon said, potentially throw the cost back onto the council and say, I can get a replacement, except that I can't afford it. So you need to help me out with that. That might work. So yeah. Cool. I think that covers all the questions I can see, unless I've missed one. So whilst we're waiting for anyone to come in, shall we talk about Suella Braverman and her little thing this week. I mean, it seems like she's on a hell-bent course to annoy Rishi Sunak and will potentially get sacked at some point, but who knows what's going on there. But what she basically said was, she was talking about making tents, as in people sleeping rough in tents, kind of illegal. I guess she's talking about kind of confiscating their tents, because it's a lifestyle to sleep in tents. So, and that's the kind of starting point. Then you've got the backlash from the charity sector, which I've seen a lot of, kind of people being outraged. But I don't know. I'm interested to see what you guys make of it. I've got a particular take on it, but yeah, I don't know if anyone had any thoughts about it. I think it was always a bit of posturing, to be honest. I don't think she's not going to be around long enough to actually put anything into place anyway. And I don't think police would even kind of be that up for enforcing it. So it just seems like a bit of a yeah, as I say, a bit of posturing. But yeah,
I find it very difficult to think about anything Suella Braverman does without becoming sort of despairing and angry, and starting to think about sort of psychology rather than politics. Because you just think, how could somebody get to be this depraved? But I was wondering when I saw this, I was thinking, where are all these tents? Because I remember, you guys probably don't remember this, you're younger than me, but back in the 80s, the area around Waterloo Station, there's a roundabout at the bottom of Waterloo Bridge, and that there's now a Miramax cinema there, but that used to be
was it the Bull Ring?
Is that what it's called?
There was one like that where there was on Trafalgar Street. I don't know, but yeah, I heard of people who went to do outreach there. It was just like Cardboard City, basically.
It was, yeah, the roundabout was cardboard. It was called Cardboard City, and it sort of it stretched down to, there's a bit where people do skateboarding under there. I don't know if you know that bit. And it was terrible. I mean, it was the smell, because there was no toilet facilities, so you can imagine it was horrible. But there was a worry that people were sort of creating. And then there was another time around St Paul's Cathedral about 5 or 10 years ago. There was people putting up tents there, and the question was whether the church supported it or not. But I don't sort of see a lot of tents. I mean, maybe I should get out more. But do you see people sleeping?
So Milton. So before lockdown, so Milton Keynes more than Bedford. So Milton Keynes, you used to see a lot of tents in the underpasses there. And Shannon and we were at Milton Keynes yesterday, actually, just at the train station, and there was maybe like 3 or 4 people kind of bedded down, but no tents. And then there's like a little bit up towards the kind of the PIP assessment centre, where some people have got. When I last went there, they had like set out like a living room. They had like, kind of bookcases and stuff like that, all like in this like kind of little alcove. So I think it's, as everyone in has kind of ended, it's certainly kind of had a bit of a bounce back of people using tents. I think it's obviously something that's, probably a very insignificant issue, which lots of voters apparently care a lot about. So which is probably why she's talking about it. But yeah, I don't know.
The other thing she was saying was it was people who from abroad who were doing it, which adds a nice little sort of racist.
I didn't even see that, but yeah,
twist. Because and I thought, well, there was a time about a few years ago when somebody like her, it wasn't her, was saying that they should deport rough sleeping migrants ought to be deported. And I thought, well, that really is sort of kicking someone when they're down, because you deny them access to housing, and then when they're stuck on the street, you then say, "Aha, how dare you do this? We're going to deport you." So it seemed like a sort of, I couldn't quite see why the people from abroad were being targeted. And the other thing is, I mean, nobody really, I mean, am I being naive? But people don't generally think, I think it'd be a good idea to live in a tent in sort of a city in England. I mean,
no, I think there's plenty. I think there's millions of people walking around who genuinely. So if you look at, I'm assuming she's appealing to what she believes is kind of her core voter, and I think there are a lot of people that certainly have that sentiment. Kind of in terms of homelessness in general is a lifestyle choice. I've met plenty of housing officers who would say that in decision letters, or whatever. So yeah, I think so I think that's what it is. I think there's a lot of people out there who have this impression that the people who are in that situation are just kind of doing it to annoy everyone, or doing it to be spiteful or something, just to kind of get in people's way. But yeah, so the support don't because yeah, it was 2 years ago. I'm assuming it must have been Pretty Patel that was talking about that. And then again, there was this kind of outcry from the charity sector saying, oh, you know, you need to support rather than deport people. So there's, you know, kind of placards going up and stuff like that. And I've similar, actually, I'm glad you kind of raised that because I had similar feelings to that as I do to this. But yeah, I don't want to jump in yet. Shannon, have you got anything to say about this one? It's all right if you don't, or if it just makes you angry.
I mean, I have lots to say. I think what's also sort of disappointing is the sector's response because they they're coming out with things like homelessness is so complex and complicated and it's so difficult to end homelessness and this is a step backwards. And I'm not saying people aren't complicated, and I'm not just talking about people going through homelessness. Everyone is complicated to a degree. You know, how you like your coffee, how, you know, whatever it is, everyone's complicated. But by making an excuse that homelessness is a complex and complicated thing, we're essentially saying, oh, it's quite difficult. We might not do it. These are complex people. It's their fault because they're so complicated and they're so difficult when actually the answer is just house them. And I'm not saying that those people might not also need support with relationships. They might not need support with mental health, with substance misuse, with whatever it might be. But the first step has got to be just house them. And when she's talking about sort of, we don't want to see, you know, tents everywhere, neither do I. Like, I agree. I agree with her. However, don't find the people, don't even find the charities, and that's a whole different, like, tangent about the charities. But why don't you find the local authorities? Why don't you make it more expensive for local authorities to make people rough sleep? And I'm using that phrase because the local authority is choosing to have rough sleepers in their town rather than the people choosing to live in the tents, because they're not making that choice. The local authority is making that choice. Because also we talk about like the law and everything that the duties have to do, you know, everything the local authority, you know, has to do legally. We've not even begun to discuss like what they have the power to do. So like we're not even, oh,
Yeah.
anyway. Yeah,
No, it's
sorry.
cool.
I
No, it's
know.
all good.
It was an invitation to have a rant, wasn't it?
Yeah. It was. Yeah, it really was. Yeah, I think.
Stopped early.
I think. So I think the question is. So why are people stuck on the streets? A lot of the time, it will be because they've been found intentionally homeless. That's probably what's keeping them. Because I would imagine most organisations kind of know they're vulnerable, and in one sense, intentional homelessness has this kind of, you know, way of looking at it, saying, well, you know, you didn't choose to be homeless, but you chose to behave in such a way that's led you to become homeless, and therefore it's your own fault, and therefore we don't care about you, and you certainly can't live in a tent because it's too warm or whatever. But the fact of the matter is, what really annoyed me about it was that out of those, they're very willing to kind of, you know, publicly decry Suella Braverman, who's just basically a pantomime villain, really, but they're not willing to go and challenge a council to show that someone's not intentionally homeless, because there's so many good defense, so many easy defenses to make to someone being intentionally homeless, particularly when they are at risk of, you know, long-term rough sleep, and they probably do have like, you know, kind of other issues going on that would probably mean that they're not intentionally homeless after all. But these organisations, I've even seen someone who I've challenged when they worked in the council. I've challenged successfully them on an intentional decision, and now they're kind of saying, "Oh, you know, this is also Ella Bradman's fault." But actually, they were someone who made a bad decision that would have led that person to probably be rough sleeping for some length of time. So it's kind of, I don't know. I just a bit like support don't deport sort of thing. They're all very willing to kind of shout about stuff, but then when you go and ask them to go and challenge a council on a really basic issue, then they kind of suddenly lose heart and they just allow it all to happen.
I wonder as well is part of it is, you know, it was the whole scrap the act. And obviously they've replaced the act and this is what they're replacing it with. And that was always going to be a potential issue because in I guess their minds, they've won because they've scrapped the act. So we're, you know,
as we're talking vagrancy act, we're talking here,
yeah.
Yeah.
So you know, well, we've scrapped the act. What more do you want? Then putting these things in, and so what I'd love to see, because again, it wasn't mentioned in the speech. I think her opposition, and I can't remember his name, basically said it wouldn't be my approach. Like, we need to tackle this stuff, but it wouldn't be my approach. So I don't know how sort of like how many legs this has, but we're all aware now of this bill. We're, you know, there's going to be consultations, there's going to be ways that you can feed back into this. And I'm not just talking about the loudest voices like Shelter or Crisis or, you know, any of those big charities, because yes, they will input. However, it's almost a given as to where they stand. But like, if you're watching these videos and you're up for it, and maybe when we become aware of these consultations and whatever, we can put it out. But you know, say your experience and like, because it's ridiculous. Anyway.
Yeah. Yeah, no, that's cool. I think it's a good shout, like to keep an eye on when it gets that far. I don't know, but yeah, I think I imagine the you guys who are kind of coming in to listen to these things probably have some very informed opinions to kind of put into that stuff. I mean, so Shannon and I did a bit of work to kind of there was a disability in housing kind of consultation back in September, and they clearly read what we said because they came back to us because I'd messed out some figures. So they said, "Yeah, what are those figures, Mike?" But so clearly they'd spent some time reading it, so it's worth doing. And certainly, unless you're doing all that stuff, there's no point getting outraged about it. So yeah, cool. All right, it's nice to have a little rant. Next question come up. So this just kind of on the same thing, really. So states thing, yeah, and this does kind of come back into what Suella's saying a little bit. So she's saying that you shouldn't be sleeping in a tent, but at the moment, councils have this policy which is unlawful to insist that rough sleeping people go and rough sleep to be verified so they can then be helped rather than accepting homes application on day one like they should do. And we've said this before, probably more than once, but so some councils have their own officers in these street outreach teams, which are the ones telling people to go and rough sleep rather than accept homeless application, rather than put them into Section 188 accommodation. And other councils are a bit more savvy. They put in like a well-meaning charity in the middle of them, so they don't have to engage with Section 184 and Section 188. But it's all in broad daylight. And as I say, I think some of these charity bosses that are getting on their high horse about it, I think when push came to shove, they'd probably go quiet again if they actually had an opportunity to challenge a council on a specific individual and win. They might be a little bit less likely to put it on their LinkedIn profiles or whatever. Anyway, so yeah, I think that's going to come up in the ethics of gatekeeping event. By the way, guys, so the verification process is definitely one of the common forms of gatekeeping, and don't know how it's got this far really. How someone hasn't sort of mentioned to them that it's not lawful. But anyway, there you are, Angela. So
I'd love to know if it's actually as far as not just not lawful, but if the housing officer is doing something illegal, or because you're then telling someone to sleep rough, and with the Vagrancy Act that still hasn't, it's not gone yet. But if you're telling someone to rough sleep in order to get housing assistance, you're not coercing them to break the law, because it's a criminal act to sleep out, So, and I know it's not going to happen. We're not going to see that, but it's an interesting one.
It is, yeah.
Can I just add a little bit that, of course, the whole, I mean, obviously, the answer to the question, and you've answered it, where it says, is this right, is clearly no, it isn't right. But it also misses the point. Homelessness isn't about being a homeless person, and you've got to prove that you are a homeless person who sleeps on the street or has been seen on the street or registered with a charity, because the definition is about not having accommodation. So you could... you don't have to show that you have become homeless. You just have to show you haven't got anywhere. You may say, well, that's the same thing, isn't it? But it isn't. So you don't. But the trouble is, isn't it? It's we're back to that thing that it's definitely wrong, but they'll get away with it because most of the time they're picking on people who can't enforce their rights. But anybody coming across that sort of thing should say no to it and look to challenge it or complain about it.
and since we're ranting, now you got me thinking about Streetlink and Chain. So, oh man, everything I'm about to say is my own opinion. Blah blah blah. But basically, so councils should accept, as Will just said, you don't have to prove you're homeless to make a homes application. But kind of they've sort of made all these kind of elaborate ways to make it look like they're doing something when they're actually not. Streetlink or whatever. Well, why not just accept the homeless application from them in the first place, so a member of the public doesn't have to report them or whatever? And with Chain, it's kind of I've never used it myself, but it's this massive database in London services, which I think they record like who's been verified and all that sort of stuff. From a data protection point of view, I don't see how that's not a breach of their human right to a private life, because I bet you most individuals who are on Chain, first of all, don't know what's recorded about them. They don't know where it's going to. They haven't been given an opportunity to object to it. It's just another sort of thing where the homeless sector kind of seems to be very kind of preoccupied with making it look like they're doing something. As Shannon says, like kind of making it. This is a really complicated issue, and so we need to be paid more because it's really you can't not anyone can do this. It has to be really expert people that do this. Anyway. So, oh, you're right. So, okay. So this is less of a rant. This is actually a sensible question based on this. Okay, so I put a question into the Facebook group. no one responded to me. I was a bit gutted. Will, you might know the answer to this, so sorry to drop you in it. In the Welsh homeless, it's not called the Homelessness Code of Guidance in Wales. It's called something else. But basically, it makes the point that it says something along the lines of people who are rough sleeping are likely to be vulnerable. So it says that in the Code of Guidance. It doesn't say that in the English Code of Guidance. However, my understanding, and this is the bit you might be able to help me out with, Will, my understanding of the definition of vulnerability within Welsh law is the same. It's the same case law that kind of forms the definition in English law, as in HOTAC, and not Smith v. Paniotu. I don't know how to say the word. Smith v. Harringay, basically. So I know this isn't kind of like a legally kind of binding argument, but if the case law is the same, if the threshold is the same, it's the same test. Is your client? Is there something about them which is going to get worse that an ordinary person without the issue wouldn't have? Blah blah blah. If that's the same, and in the Welsh code it says, if you're rough sleeping, you're likely to be vulnerable. Is it not kind of possible to like underline the fact that yes, anyone who is rough sleeping for any length of time at all is likely to be vulnerable because of the coexisting. I need to get the wording because oh man, let me just pull up the Facebook group.
Yeah, I'm just googling
the Welsh what the Welsh thing actually said. Because I know there are some very minor differences elsewhere with the Welsh definition, but it's not about the threshold. It's about, so I think, for example, pregnancies kind of dealt with differently. So I think intentionality doesn't come into it if you're pregnant or something like that in Wales. I don't quote me on this, but this, as I say, it doesn't change the actual definition. Here we go. So right. So this is what the Welsh guidance says. People who are sleeping rough are likely to be vulnerable due to the health and social implications of their situation. Now, if it's the same threshold, then I know it's not legally binding, but that seems to me to be a helpful bit of kind of statutory guidance to kind of underline that when people are rough sleeping, they're probably going to be vulnerable. There's certainly going to be reason to believe, or almost certainly going to be reason to believe that they might be vulnerable, and therefore hit that threshold of having the duties for interim accommodation. But yeah, I don't know. Yeah, I put you on the spot, Will. So don't read a text.
Yeah, I mean, did I mute myself?
No, you're good. Yeah.
I always found that the Welsh approach to homelessness was always a bit ahead of us and a bit more sort of humane. But I'm not aware of anything on that. Although, if it just says that rough sleeping will be likely to be indicative of vulnerability, the danger is that that's, as you say, that's not going to bind a unsympathetic housing officer who'll say, well, I take that on board, but in this particular case, I don't agree.
No, I agree. You're not going to win an argument with a housing officer on an individual case, but when you're talking to whoever it is that came up with the verification process, it's kind of like it's a little bit of a strengthens the point of this group as a whole. Most of them, if not all of them, most of them will be vulnerable because of the nature of their situation, and therefore to have to have a practice which basically says, well, we're not going to accept an application from you, we're not going to put you in interim accommodation, go and rough sleep, and we may, if we get around to it, come and find you and then verify you. Then that's there's something just a bit off about that. Well, more than off about that.
It does also get you into a realm of sort of local government thinking, which can sometimes seem really perverse, because one of the tests of vulnerability that's come out post sort of Hotak and Paniatu is this idea that it's not about whether you would suffer harm or injury if you became homeless, which was the old-fashioned one, but there's also this idea that you might find it more difficult to cope with the effects of homelessness. Sorry, I've got some noise in the background, but now that leads to all these decisions where because basically coping with the effects of homelessness, to my mind, means being able to get out of being homeless. So that if you become homeless, you'd be able to go and find somewhere yourself. That's what it means. But you get these decision letters where they say, well, coping with homelessness is okay. You can go to there's a public toilet at this place, and you can go and get, I've seen this, nutritious ready-made salads and meals at Sainsbury's, whatever the little Sainsbury's are called, Metro, whatever. And so you get into this idea that actually rough sleeping can be a sort of positive experience which you can cope with, which is dangerous. But I tend to think that anybody who has become and remained homeless and is rough sleeping, to go back to where we were, is failing to cope with the effects of homelessness. And I don't think anyone can say that it's a positive lifestyle step. So you'd have to say things are deteriorating. I mean, the more nights you spend on the street, the more the effects are going to weigh down on you. So I think you can sort of, the logic of saying it's indicative, I mean, it is good there. But I personally don't tend to deal with many people who are sleeping rough, or have been sleeping rough, where it's argued you're not in priority need. It's usually people who are sofa surfing.
I think the charity sector in effect probably is not apt to get people legal help from someone like yourself. Well, I think they effectively block a whole cohort of people from actually accessing legal services, because they've got the verification process and all that sort of stuff, and they get all this additional support, but they're not treated as citizens because they're not given the choice of making an application and going down that route. They can, I'm not saying that, when COVID hit Bedford, the Mercure Hotel, the 4-star hotel, was used as the everyone in, and people were saying, no, I don't want to make a homeless application because I get 3 meals a day in the Mercure. I'm going to go there. It's nicer. So that worked. That's the way it should be. But you can't just say, well, we're not going to take a homeless application. You're going to only have the option of this one over here, because that's not the way it should work. And I agree with you. I would say the whole point of the vulnerability test is, who needs help to get off, to not be homeless anymore, and who doesn't, who's going to sort themselves out and who's not. So if you've got someone who's been rough sleeping for any length of time, not only would their circumstances probably got worse, but that's evidence that they, as you say, they're not able to deal with the effects of or the consequences of homelessness. And that's the whole point of the test, is so that they don't remain homeless.
And taking it a step further, without wishing to sound like I'm being patronising or offensive, that sleeping rough can also be indicative of difficulties in looking after yourself generally, rather than just coping with homelessness. And so it may be that somebody that's been sleeping rough, you can't just sort of put them in a hostel and everything will be all right. There may be issues that need to be addressed. And one of the things to bear in mind is that the Homelessness Reduction Act does include in the duty to assess somebody's needs, not just how they became homeless, what sort of accommodation is suitable, but also what level of support they need in maintaining that accommodation. And the Code of Guidance, I think, does say you may wish to ask social services to assist with this. So that's, I think, really important.
And that's another thing. So social care is another thing that people who are homeless don't tend to get the option of. So they'll get like a support worker from a charity, but they're not a social worker. And Shannon and I were talking about. So Shannon was involved in research recently. I don't know if am I going to steal the thunder if I talk about the kind of the dependent. I won't. No, I won't. So Shanna's talking at a conference tomorrow about it. I'll leave that off. I won't make that point. But yeah, so but lots of homeless people almost kind of, even though they would hit the eligibility criteria for social care, don't get that option because even no one thinks of it, or social workers don't like working with homeless people, or I don't know what it is, but they don't kind of get that option either, which again seems to be a bit of an injustice.
Wonder, like, so you're talking about the Welsh sort of equivalent of code of guidance and stuff, because in the English code of guidance, doesn't it say about in regards to priority need, history of rough sleeping?
Yeah.
Now, what counts as
8.40.
history? Like, is that yesterday? Like, and how far do you reckon you could push that with, you know, what else you were saying, Will, there about like, well, actually, if you're rough sleeping, it probably alludes to, you know, sort of a lack of being able to look after yourself, or a lack of to reach out and all of these other issues. Then that history of rough sleeping, even if it's one night, well, I've got a history of rough sleeping now. I've rough slept for one night, and I don't know, like, yeah, do you think that would, or do you think it needs to be like a long history, or?
I would read it. It needs to be more than one night. The way I would read that paragraph is it's kind of saying, well, if you rough slept at some point in the past, you then secured accommodation, then you rough sleeping again. That's how I would read it. It doesn't, but you know, I think you could interpret it your way in terms of it's not the, you know, I think it's just kind of saying, well, it's been an issue for you because, you know, your house burns down, you go and sleep in a car. Technically, you're rough sleeping, but you're not. Well, you're in priority because of the house fire, but you're not vulnerable on that first night. But if 4 weeks later you're still there, and maybe, you know, maybe you might be vulnerable now. But I think that's obviously like most people who end up sleeping rough for any length of time, they've already been failed by the system somewhere generally. At least once, you know, significantly.
It's all about indicative, isn't it? Because it's not necessarily going to, there'll always be exceptions, but it's the same thing that sleeping rough is probably indicative of a history of some form of abuse. There are reasons why you fall through the safety net. You run out of friends, you behave. It's as I see it, you can't really end up becoming street homeless without having some sort of genuine difficulty. Or I mean, it could just be very bad luck, I suppose, but it's very unlikely to be that.
Yeah, it'd be like single cases. Like that's most of my work has been in that sector, and I've yeah, never seen anyone choosing it, ever. So but no, and so Paul Anson, who he's just done his PhD, really, he talks about this kind of fact. Well, if you go and house, so if for example, I think he's talking about London. So if you've got like someone who's from the street community, where it is a genuine community, you know, friends, and it's kind of close knit community, then you get housed 2 hours away, and you know you've got a house, but you know no one, and you don't, you know, you just haven't got the ability to kind of to put roots down. Then people might, in that sense, they're choosing, yeah, they're abandoning the property, but it's not reasonable to continue to talk about. It's not suitable. His whole PhD is about I think the kind of geographical location of housing, or of your home. So this is obviously going to be relevant to councils placing people outside of area. But yeah, he talks really kind of I know, just, yeah, very weighty voice, I guess. When he talks, you kind of listen to what he's saying. So it's not out publicly yet, but it's out beginning of next year, I think. But yeah, yeah. So I think it's not a free choice, but you know, it might be times where there's the push factors is kind of, you know, from the outside it might seem at first like a choice, but it's not really. Okay, so 8:25, guys. If you're watching this and you want to get a question in, now's the time, because we're going to talk a little bit more about a few things, but then we're going to start winding things up. So the other question I sent through to you guys, it's a pretty straightforward one about local connection. Now, I've done a few videos on, just discrete videos on local connection on this channel. So, and I'd say that they cover the basics. But the question, I guess, it just kind of brings out another point when I can find the actual thing. Just bear with me. Here we are. Cool. So, here's the question. So I was born in a borough and I lived in that borough until I was 19. Then I had to move to a different borough for a good 5 years. Can I apply homeless application to my old borough where I was born? If so, how can I battle them so they don't try to push me out by saying that they cannot help me? I can show them my education and work in my old borough, but I know they'll try to make it hard for me to accept. So, because and force me to go to the borough I was in for 5 years. So, it's a common question, which I think is why it's probably worth revisiting. So you've got someone, they're basically born and bred in one area, but they've moved away for 5 years, and I'm assuming they're now homeless, which is the reason for this question. Can they apply as homeless to the area they're born in? First thing that's really important to say on this is that we need to make sure that we're talking about a Part 7 application, a homelessness application, rather than a Part 6 application, which is just where anyone can apply to any council, but there's very strict criteria around local connection. Now, under certain, the Part 7 definition is you've got local connection if you've lived in settled accommodation for somewhere for either 6 out of the last 12 months and or 3 out of the last 5 years. So someone who's moved away from an area for 5 years won't have a connection under that definition. Then you've got people who've got family who've lived in an area for at least 5 years, and it needs to be close family in terms of people you kind of have a meaningful relationship with. And you've also got employment, but it doesn't kind of specify how many hours or anything like that. So the Part 6 definition will often say, you need to work 16 hours and it needs to be for a year or something, whereas Part 7 doesn't take that into account. And then you've got sort of special circumstances like people rough sleeping or people who come through the immigration system. But in this situation, just because you're born and bred in an area does not mean you still have any connection to it, other than potentially you may have family there, basically. So you'd be more likely than not, I guess, you'd have family still living in the area. The coded guidance, which is worth reading, it kind of talks about, it's not about the kind of degree of blood relation, it's more about the quality of the relationship with that family member. So it could be aunts, uncles, step parents, all that sort of thing. It doesn't have to be immediate family, but you do need to have like a meaningful relationship with them, which falls short of having to give or receive care, which again is a Part 6 thing. So Part 6, you have local connection if you are getting carers allowance for someone. That seems to be how it's kind of done in Part 6, but Part 7 is different. But it's not, one sense, it's not, if you don't hit those criteria, the council's not been difficult with you when you go and apply to them. They're well within their rights to say, you don't have a local connection here. This is what the definition is. You need to go back. Technically they should accept the application and refer them back. But ultimately that person is going to end up in the council where they do have a local connection, except where a council's been exceptionally nice, because councils don't have to look at local connection. It's not a duty. They can choose not to look at local connection, but every council pretty much will do. Unless, of course, again, you might have a situation where you were in one area, grew up there, moved to another area, and then you were subject to abuse in that second area, in which case you could go anywhere in the country, which would include that area you grew up in. But other than that, there's not. Yeah, that's kind of it. It's to say it's not councils being difficult. That's just what their criteria says, and that's something that they can legitimately save themselves money by not helping you out. Anyone else want to add anything to that at all?
I guess as well, would it also be the case, say, if that person had family in that area where they have current local connection to, but they didn't want to positively live there, then they could also apply. So say you move to this new area for 5 years to be nearer to a brother, and then that brother turns out to be whatever, and then you don't positively want to live there, then you wouldn't have a local connection to that area, would you?
You'd have
Does
it
it
through.
override it?
You'd have it through residency still. I think so. So I've worked with people who have basically gone to an area and they've been rough sleeping, so they wouldn't have local connection through residency because they've not had settled accommodation. So yeah, you're absolutely right. I'm literally thinking of siblings I worked with for a long time in Bedford, where in that situation neither of them had local connection through settled accommodation because they've both been rough sleeping. But each of them had been in the area for 5 years, and it doesn't stipulate that they need to have been in settled accommodation for 5 years for the family member. So they basically both got local connection through the other one. It's a weird situation, but I don't know if that made sense. But that's kind of, you're right. So you couldn't be referred to an area where through family connection where you positively don't want to live. But if you had residency connection there, then that would kind of override it, I guess, or work the same as. Okay, cool. So we've got two questions come in. Someone's made a homeless application, suffered from mental health issues, and not vertigo. What's the word? Scared, fear of heights, to whatever it is. How do I ask them to help me with ground floor flat? What evidence will I need to provide? So the answer is some pretty detailed evidence, because it can be done, but you'll need to show, and I've done this with, I remember two individuals I've done this argument with, where there was supporting evidence that yes, they did it. What's the actual technical term of fear of heights? I can't remember, but yeah,
It's
yeah.
vertigo, isn't it?
No, that's
Oh.
like dizziness. It's like
Is there something phobia?
acrophobia, I think, something like that. But yeah, so they got a GP letter basically saying yes, it's serious acrophobia. This person experiences severe anxiety around heights, and it didn't equal having a ground floor flat, but it did mean that they didn't end up in a 10th floor of a high rise or something. So yeah, I think that's you can always ask someone. You can always ask a counsellor. It's always important to lay out what your health issues are and what kind of things like anxiety stuff. I don't know whether phobias count as a disability. I guess they could. It's an impairment which could have a substantial impact on your kind of day-to-day living activities, but it needs to be pretty extreme, I think. But yeah, so it can be done. It's all down to the quality of the detail of the medical evidence you're able to get. Anyone else want to stand in on that one?
I used to do quite a lot of work with people refusing or saying I can't live in accommodation because I've got a fear of heights, and it was difficult to prove it because it's very easy to say you've got a fear of heights, but difficult, almost impossible to prove it. So I did used to have ridiculous situations of referring people to psychiatrists who would say, yes, I'm a psychiatrist, I've spoken to this person, I think it's a genuine fear of heights. And that would work. And then another one would be to get evidence from sort of workplaces and things to say, yes, this person worked here and they couldn't go to the second floor or something. We used to have to make adjustments for them. But it doesn't seem to come up so much now. But I mean, it's just a question of getting evidence, isn't it? But it could amount to quite a prominent.
Yeah, there was quite a prominent case which I've seen cited quite a lot on a similar kind of issue. So I think it was someone like a former asylum seeker who'd been tortured in their home country, and where they were tortured had these little round porthole windows, and in the block of flats that they were kind of housed in had the same type of and the psychiatrist was basically said it's kind of triggering PTSD or kind of whatever, and I'm pretty sure that was a successful case where they got moved. But you need I think that kind of actually that sort of like historical evidence from previous employers and stuff might be probably more helpful than just a GP letter.
Actually, it's a famous case. I think it's the case of Poshtay, isn't it? And Kensington and Chelsea, 2015, where the windows reminded them of the windows where they'd been in prison, and it was held. It's sort of subjective suitability that little round windows might not be suitable for the rest of us, but if you've been in a prison with little round windows. Sorry, I'm repeating what you're saying. I was just thinking. I know this is a big.
Yeah, no, I've seen it. I've read the case a few times.
Yes.
So yeah, it's POSHTEH. If anyone's interested in checking it out. So yeah.
Sorry.
Cool. So, next one. Someone more than 14 years battling to be accommodated in the area. Mother lives there for more than 20 years. And still difficult to secure permanent accommodation. So I'm going to guess this person is talking about somewhere in London, because it's not unusual for waiting times in London to be in excess of 10 years easily. Average waiting times in London are sort of 10 years. So that would suggest that you will get some people who've been on waiting for 15 or 20 years sometimes. That doesn't necessarily mean the council's breaking the law. That's one of the kind of the problems we've got at the moment, is you can get the council to follow the law and the person's still stuffed because they're in temporary accommodation for the next however many years. So, a lot of people in that situation effectively treat their temporary accommodation as if that's their long-term home, because they know they're going to be there for years. And if you think about it, a lot of people in that situation will be in their accommodation much longer than they would be in an assured short hold tenancy. So in one sense, it's in one sense it's kind of more settled than lots of private rented accommodation that you might get. But yeah, it's if you've been accepted onto the housing register and you're on the right banding, then the council's done their job lawfully, and the waiting times. There might be some ways you can challenge. So as me and Shannon did some work recently looking at average waiting times for different councils and how having a disability would often mean that you had to wait a lot longer because they haven't built enough accessible housing. That's an issue of law. You can challenge the council in general on that and basically say, why have they not secured enough or built enough of the right type of housing? Whether that's actually going to help you individually, I don't know, but there's a legal argument to make there, but a lot of the time they won't be. I'm just checking this. So there's just a follow-on comment there. Yeah, yeah, just kind of there's just more just kind of reiterating that. Yeah, okay. So, and I think the follow-up comment there as well is just talking about how councils can house you in social housing, but they can also discharge their duty into the private sector. And in theory, the discharge of duty into the private sector should be with a non-rogue landlord. So there should be a right and proper person. It should be affordable. It should be at least a 12-month tenancy if it's a main housing duty. This is the thing that I changed with the HRA that I didn't realise. They can make a 6-month tenancy available to you if it's in the relief stage. So that's still legal. It's just the law sucks. It's not that and housing stock sucks. It's not that the council's necessarily doing anything wrong there. They're acting within the law. Okay, so we've had over an hour. Unless there are some very, very quick questions right now, and we've got a 30-second leg, so you better be super quick. We'll call it a night. Just to reiterate, we cited your website last week, Will, because someone was talking about legal aid funded solicitors. So check out, if you look at the description of the last week's video, guys. So Will on his website has done kind of a fairly comprehensive list. I'm sure there's one's missing out somewhere, but a list of solicitor firms that take legal aid for housing cases. So it's a legal issue. If you can get a solicitor, you're onto a winner. You're in a far better position you would be if you didn't have that. So do check that out. Shannon and I deliver training regularly. The next date with spaces is the 8th of December and then the 19th of January. So the 8th of December is filling up, but the January ones, there's no one booked on yet, I don't think. So do check that out. Again, look on our Eventbrite or Facebook page, or whatever, you get some details of that. And with the ethics event, just genuinely for me, I think one of the best things we can do about gatekeeping is just talk about it openly and kind of, just ask, just kind of get that conversation out there, really. So lovely to have everyone here at the event in 2 weeks' time. If you've got any friends or colleagues or whatever that might be interested, please do let them know about it. The more people, I think, hear it, the probably more effect it will have. And as I say, I think it could have some pretty cool effects in time. So yeah, there's no further questions. We'll call that a night, guys. Thanks very much, Will and Shannon. We'll see everyone same time next week. Will and Shannon, you around next week? Do you know?
Yeah, I should be around.
Yeah, cool. So be a trio again. But yeah, take it easy, guys. So yeah, I'll just question there about the solicitor list. I'll put it into the description, not the live stream, not the live chat of this video. So I'll do it now. So check out the description of the video, and it should come up. But yeah, nice one.